Divorce Talk Radio does not give legal advice, neither does it reflect the views of Rockford College. To obtain legal advice, you need to retain an attorney in your own jurisdiction.
Good evening, folks, and welcome to Divorce Talk Radio. This is attorney Brad Tengler. Our topic for discussion this evening is orders of protection. I'm here in the studio with Jeff Carter, and we will be talking about how to obtain an order of protection, what is required for it, no stalking orders as well, hopefully to help people understand the process a little better, at least here in Winnebago County and in Illinois.
Well, it's good to be here, and it's good to be talking about something really important like orders of protection, because obviously there's a lot of people out there who need them.
Sure. So let's start out then, and explain to me what exactly is orders of protection, also known as the restraining order. What exactly is that?
Basically, an order of protection is this. When someone is being abused or neglected, and they need immediate assistance from a court to help them be protected, they file these orders of protection, so they're not going to continue to be abused or neglected, or the person on which they're petitioning to be protected will not continue to be abused or neglected.
Now, a lot of times I see that, like, my friends' girlfriends or something like that, they're the ones that really do that, but it doesn't have to be somebody you're involved with relationship-wise. It could be a neighbor, or it could be somebody you just ran into, they have a problem with. It doesn't have to be technically in a relationship with, correct?
That's a real good question, and I'll read part of the statute for you. It comes out of Section 201, and these are the people that are protected by the Act. Any person abused by a family or household member, any high-risk adult with disabilities who is abused or neglected, any minor child or dependent adult in the care of such person, or any person residing or employed at a private home or public shelter which is housing an abused family or household member. So basically this, you can't get an order of protection against your neighbor if your neighbor is abusing you, because they're not a household member. But if it's your girlfriend, if it's your boyfriend, if it's a parent, if it's anyone residing in your home, or if it is a child. Go ahead. Yeah, I see you got a question.
Well, basically I'm saying is, as long as you're involved with them somehow, because I do know somebody, a friend of mine has, split up from her boyfriend or whatever, and he was threatening abuse, like, well, I'm going to kidnap the child and take it out of state or hurt it physically. I mean, you could do that even though they do not live together.
They're in a relationship, or recently were in a relationship, and so that would apply.
All right, I wanted to make sure. Okay.
But the one exception to that is children. So let's say your neighbor's child is being abused. If your neighbor's child is being abused by the neighbor or by someone else, you can file an order you can petition the court for an order of protection on behalf of that child, even though you're not a household member with that child. Is that rare? Yes.
Oh, yeah. Huh.
Yeah. I
didn't know you could do that for somebody else.
Yeah, you can do that. You can do that.
Now, how exactly, okay, let's say something goes wrong and you have an argument with your boyfriend or girlfriend or whatever situation, parent that lives with you. When are the availability for you, to go get this restraining order or go get this order of protection? Is that something you can get 24 hours a day if something's going on? Hey, I need to have this.
You can't get it 24 hours a day, but it's pretty close.
Okay.
Meaning this. You got into a fight with your significant other the night before. He was really drunk and he threw you up against the wall. All right? Obviously, if it's midnight, no court is open. So what do you do in a situation like that? You call the police.
Okay.
All right? The police come. They separate you two. They might arrest your boyfriend. They may not.
Right.
But they separate you two. And then the next morning at 8 o'clock in the morning, you march yourself down to the courthouse and you file a petition for what's called an ex parte order of protection.
Okay. So the courthouse is one of
what that means too.
Oh, go ahead.
Ex parte simply means this, that you are permitted to get an order of protection without the other party, that would be the abusive boyfriend in this situation, being able to be in court at the same time. That's called an ex parte order of protection. They last for 2 weeks. And the court, if they find that there is the type of abuse that necessitates that kind of protection, they'll grant an order of protection for a 2-week period of time, even before the boyfriend has the opportunity to testify in court.
I guess my question is, what on certain things like that, like if you're afraid of getting hurt or something like that, and you have these order of protections, what does it really do? Does it pretty much just go on your record saying, hey, if the police pick this guy up, hey, you're not supposed to be around here? How exactly does that work? Like, what does it help benefit you? Because some people, that may or may not stop them from doing something.
Oftentimes it doesn't stop people, which is very, very foolish, and this is why. The first time you violate an order of protection, guess what? That's a criminal misdemeanor.
Oh, wow.
If it continues, they can charge it as a felony. So, and by when the judge orders someone not to communicate with the other person, that means by any means. That means by Facebook, by email, by texting, obviously in person. So, you send a text to your girlfriend, no, threatening or otherwise. It could be threatening, or it could be, hey, I miss you, I want to see you. Boom, you just violated the order of protection.
Whoa.
An ex parte order of protection, which you haven't even been able to appear in court yet for, and that is a criminal misdemeanor. And obviously you have to be served with that ex parte order of protection before it has criminal implications if you violate it. But if you've been served, man, you cannot communicate with that other person if the court has ordered that.
Wow. Okay, here's my question. Let's say I'm dating a girl, or if I have a kid with a girl, or married to a girl, whatever, we just fall off and we have a problem with each other, and she comes after me, slashes my tires or whatever, and I decide to get, whatever the case may be, and I decide to get a order of protection. I go down to the courthouse and get that. How long does that last? Is that like a month thing? Is that a weekend thing? Or how does it depend on how severe the case is? How does that work?
Good question. Orders of protection, ex parte orders of protection last for 2 weeks. So that means after the 2-week period of time, the respondent, the defendant in the case, in this case it would be the girlfriend who slashed your tires.
Sure.
She has a right to go in front of the judge and say, Judge, I did not do that, and this other person did it, I think, and the judge gets to weigh and hear the evidence and make a decision about that. But let's say the girlfriend goes and says, hey, Judge, I did not do this, and the judge looks at her and says, ma'am, I do not believe you. Look at the pictures that your boyfriend has. He has a picture of you slashing his tires.
Right.
Or there's a video from Kmart's parking lot showing that you slashed his tires. The order of protection can last for up to 2 years.
Wow.
Yeah. So a 2-year period of time. And in addition, if there are children between the parties, those children fall under the protection of the order of protection as well. And so there's implications about visitation, custody, all that kind of stuff.
So when you go apply for an order of protection for somebody, whatever the situation may be, how long does it normally take for you to get that? I'm guessing there's some that they screen
that day.
Oh, really?
You'll get it that day.
But do they look up to see, because there's some women that I know, and I'm sure there's men also, that just do that with everybody, and they kind of like to cause kind of like a problem almost, like drama. I mean, I could see where, I actually know a female in Rockford that's done it 6-7 different people she's done that on. And it's almost like, when you do that many times, is it them or is it you that's just trying to cause a scene?
I think I hear what you're saying. You're saying, what happens, what does the court do when someone is lying?
Right.
Is that what you're saying?
Right, exactly.
Yeah. Obviously, as attorneys, we have to deal with this kind of situation from both sides. We got to make sure that our client isn't lying. And if the other side is lying, we got to find ways to show that they're lying. People sometimes lie when custody is at stake. And that's what is sometimes and often is at stake in these situations where someone is, screaming abuse, abuse, abuse. What if it's mutual abuse?
Okay.
There's a fight that ensues between a husband and wife, and both are being physically violent. Now, obviously, generally men are larger and stronger than women, and that they can cause a lot more damage. But the key thing that the judge has to weigh is, are they lying? whether it's the man who's saying she slashed my tires or whether it's the woman who's saying he slashed my tires, are they lying? And then what am I going to do about the defendant if the judge finds that they're not lying about how much time the defendant should get with the kids? Is he or she a danger to the children? Mm-hmm. Which, if there is the possibility of a 2-year order of protection being set in place, that can have serious consequences about the amount of time you're allowed to be around your kids.
If you're going to file an order of protection, do you have to have an attorney, or is it just strongly advised? It's probably strongly advised.
Sometimes people come to me and say, hey, I need an order of protection, and I grill them. I say, what happened? When did it happen? What was going on? Uh-huh. And I tell them, hey, don't waste your time right now on paying me to show up to the ex parte hearing. Just get into court. I can't be there today at 1 o'clock in the afternoon, but you get into court, you tell the judge your story, mm-hmm. and he's going to grant, or she is going to grant, your order of protection, because there's real bad things that is happening. A woman comes into my office with a black eye or pictures of her car being destroyed by a boyfriend that was coming after her. Mm-hmm. You just bring those pictures in the court, and guess what? The judge is going to know what to do, which is to grant you an order of protection.
Now, to file an order of protection, is there fees involved in that at all, or is that something that's free? Not free.
No fees.
Oh, at all.
Unlike a normal family case for custody or paternity or a divorce case, there is no filing fee associated with a petition for an order of protection.
Okay.
And I think there's a policy reason behind that, because our legislature and the court system wants to ensure that people have easy access to protection. I mean, if it costs $167 to file an order of protection when your boyfriend is beating you up and he also controls the bank accounts, guess what? You're not going to be able to get your order of protection. So there's no filing fee associated with it here in Winnebago County.
Now, what about if you switch your address or something and you're within a certain amount of time, it might be a few months or 2 years or whatever, does that just carry over wherever you are if you have a order of protection against you or somebody else? And does that just go pretty much anywhere you go to? Or how does that work? Can you have it if you move? Can you have it to where this person you have one against does not, it remains confidential where they can't find out where you live? Or
it depends.
Okay.
I think I hear multiple questions.
Yeah, I'm sorry.
That's all right. The first question is, if you move from your address that you were residing at when you were being abused,
right,
and you move to another address,
yep,
will you be protected at that other address?
Exactly.
The answer to that is yes and no. The judge orders in a lot of orders of protection that the defendant cannot be at certain addresses. So it might be the workplace of the plaintiff. It might be the residential address of the plaintiff. It might be at other areas where the plaintiff usually goes to. But the judge also in that order will usually put that the defendant has to stay away from the plaintiff within 300 feet or outside of 300 feet. So then, you don't have to worry about whether or not you're moving to a different residence. Now, if you switch to another place of employment, you might want something specific in there about, to have it modified, and you can go back into court and have your order of protection modified to protect you from having the defendant show up at your place of employment if that has been an issue in the past.
Okay. Now, if you have a child with the person, either male or female, you have a child with them, and you're getting physically abused by either one, and when you go to this court or when you file this order of protection, does that also include what have things to do with parenting time and custody and child support payments? Is that completely different? Are those
all those things can be taken care of in an order of protection?
Oh, they can. Okay.
Custody, visitation, and child support.
Okay.
A court has jurisdiction under the statutes dealing with orders of protection to address visitation, to address child support, all those kinds of things. So, and the reason, it's a logical reason. If, a couple is married and let's say in this case, the wife is physically abusive, and she is, physically abusive to the husband in front of the children, and the children are witnessing violence, and the children are being threatened themselves by the possibility of violence because they're seeing violence. If the wife is pulling out a knife or something like that,
Sure.
obviously the kids are in danger as well. And so the judge has the ability to address whether or not the wife should have visitation if he grants the plaintiff husband the order of protection, and what kind of visitation, supervised, unsupervised, how many hours, where it should be. And then in addition to address the financial issue of child support.
So you're saying also though the child may be included for protection as well. Like if you, let's say I'm a working father and the mother of the child decides to hurt me or whatever it is, can I have it to where if I go drop off my child to my grandma or whoever to babysit, same thing as, but the significant other cannot go and try to see the kid, or how does that work exactly? Is that, see what I'm saying?
I think so.
Can you involve the child as well? Can you and yourself, female or male, can you and the child both have the order of protection against whoever it is?
Absolutely.
Okay.
The statute provides who are protected parties. Protected parties are abused adults.
Okay.
They are abused children. And anyone can file a petition on behalf of an abused child.
Okay.
And that includes, your neighbor.
Okay.
If your neighbor sees that you're beating up your kid,
Right.
boom,
Okay.
they can file for a petition for an order of protection and get one. It's not that they want custody of your child. It's that they want your child protected because they see abuse going on. I mean, oftentimes in those cases, DCFS gets involved too, because not only neighbors usually don't file a petition for an order of protection against a neighborhood kid, but they might call DCFS, or a teacher might call DCFS, or a doctor might call DCFS, because otherwise the doctor, the teacher, has to show up in court personally, and they might not want to do that. They might want to not be that personally involved. They just might want to call DCFS, and then DCFS does what they do, and they might interview the doctor or the teacher or the neighbor.
Sure.
But then you're less likely to be called into court.
Now, okay, so what exactly happens if I'm a female or whatever, and I decide to go file this order of protection? What happens automatically? You say the same day you get the order of protection for this against this person.
Yep.
I'm guessing the sheriff or police officer serves the
Sheriff, police officer has to serve it.
And what happens if they cannot find the person?
That sometimes
probably
is
happens a lot, right?
But one of the ways that makes it easier to find the person is the fact that they often don't know that an order of protection is being filed against them. So, they get home from work, and the girlfriend knows where he lives, and the sheriff's there waiting for him with an order of protection. Or, they know the girlfriend knows where he works.
I think
go at 9 a.m. to this place of employment, and you will find him there in this room.
Okay, my next question is, what exactly is an injunction against harassment? That sounds like a big word.
Basically, in addition to orders of protection, you also can obtain no stalking orders. No stalking orders are not cases in which there's been some kind of physical abuse.
Okay.
All right? It's not where your boyfriend punched you in the face. And in addition, and here's the key thing, is that orders of protection only cover what kinds of relationships? Basically domestic relationships, except with the exception of children.
Right.
And so boyfriends, girlfriends, former girlfriends, husbands, wives, those kinds of folks have what's called standing under the statute to obtain an order of protection. However, what if your neighbor keeps looking in your window at night? What if your neighbor keeps sending you angry texts with all kinds of swear words in it? What if your neighbor, keeps showing up at your place of employment? Is there any protection under the order of protection statute? No, there's not. So what do people have to do? Well, they can file for no stalking orders, which is a relatively new remedy. People used not to have this option. So they can go into court and say, Judge, this person repeatedly is sending me inappropriate messages, is repeatedly calling me when I've specifically told them not to. This is harassment. I'd like some kind of no stalking order entered against this person, and the judge will do that.
So it's same thing as if you work somewhere and some random person comes in constantly or calls you constantly or Facebook stalks you. That all counts underneath that. Then something like,
yeah, if you tell them, hey,
leave me alone, or
please stop doing this, and they continue to do it, that's stalking. Now the key word there is repeated. Okay, so if some guy, if it's a girl who, some guy asks a girl out or something like that, and the girl's not interested in him at all, that's not stalking if it's the first time. But if he continues to do that when she has said no, please stop communicating with me, then that is going to be considered stalking by the judge, and the judge is obviously going to enter an order that protects her. And depending on the severity of the case, depends on the severity of what the judge will do.
Okay.
If what he's texting her, saying her, is filled with vulgarity or threatening violence, well, that's a different situation.
Now, what about? Are there ever a situation where what happens if something gets denied? Can a judge deny you for an order of protection? I'm guessing.
Absolutely.
What would be a reason why, though?
They don't believe the person. They get up in front of the judge and they say, hey, I'd like an order of protection, and the judge asks them questions and they don't believe them. Now, I think judges are hesitant to do that because they're weighing the risks. What if they don't believe them and it really is happening and then this person ends up dead? I mean, you can imagine just as a human being the kind of feeling you would have about that.
Sure.
But often, it's relatively common. I would not say the norm, but it happens that someone asks for an ex parte order of protection. The kind of protection, the kind of order that is entered without the other party being present, and the judge says, well, I'm not going to grant the ex parte, but I'll come back in 2 weeks and let's have a full hearing on this, and the other person can testify and you can testify, and then I'll make a final determination about what I'll do.
Okay.
And obviously there are criminal remedies as well. If your boyfriend punches you in the face, that's not just grounds to get an order of protection, it's a criminal act. And so the state's attorney can step in there and file a complaint for domestic battery, and then you've got a criminal case on your hands.
So some of these cases, Brad, then do end up in criminal court cases then as well then?
Absolutely. In fact, when there's very serious domestic violence, they're going to end up in criminal court. I've seen a judge consolidate a divorce case, a domestic battery case, and an order of protection all into the same case in a criminal courtroom because the judge is concerned that what is going on is criminal and that will affect the divorce. That's unusual when all three of those are combined, but it is not unusual to have the OP combined with a domestic battery case. And by OP, I mean order of protection case.
Now, let's say you have a problem with somebody, ex-boyfriend, ex-girlfriend, or whatever, and nothing's really happened yet, but maybe you've seen them have drug problems, or they've had...
Well, that's something that's happened then.
But not with you, though. I'm saying, let's say I'm a girl, and I'm afraid of getting physically damaged or physically hurt, or my kid physically getting hurt, and I had a child with this other person or whatever. Can you have one in case of something, like you're afraid something may happen to you? Can you have one done anyway based on if there is a record already?
I see what you're saying, but I don't think that's speculative.
Okay.
I think that if a young woman has had a child, and she has noticed drug behavior of her paramour or ex-boyfriend.
Sure.
That's not something that just might happen. If he is using drugs around the kids, she's noticed that he's been high. Absolutely.
Okay.
I mean that is grounds to go into court and say, Judge, I need an order of protection because every time, Mr. Loverboy shows up at my house, he's high on coke.
Okay.
So that, and obviously nothing has happened to the kids yet, but that's negligent behavior. In fact, quite honestly, if she permits him to take the children while he is high on coke, she's the one who's being negligent.
Oh, right.
I mean, she's not engaged in protective parenting, and DCFS might get involved.
So when you go to the courthouse, then you're actually the first time you go to file an order of protection, you are talking to a judge. It's not like
That
you
is
go
correct.
fill out, okay, so
You file that petition, unlike any other petition. I mean, when I file my normal petitions, it usually takes me 2 or 3 weeks to get in court.
wow.
You know, but when you file for an order of protection as an individual without an attorney, you will be in front of a judge within 4 hours.
Whoa.
Yeah,
And it must be real busy down there too. I'm guessing this happens quite a bit.
unbelievable, unbelievable. In Rockford, our courtrooms are packed with orders of protection, and our judges do a fantastic job at addressing those issues. But it is packed, and it's because they have a statutory obligation to hear these right away, and for good reason. If they don't, someone might end up dead.
So pretty much, if I get an order of protection against somebody, and this is the whole court order thing, then the person I'm having it against is legally supposed to have to show up in court. Then they have to go.
If the defendant doesn't show up, are you talking about the defendant or the plaintiff?
Right, the person you're filing one against, obviously they're going to serve them the order of protection, so
Right.
you have to go to. They're supposed to go to court for that thing.
Well, if they don't go to court, it's not as if they are going to be held in contempt. Okay,
okay,
but the bad consequence is that the judge is going to completely rule against them because they never bothered to show up in court and testify on their behalf. So if, their girlfriend is saying, he threw me against the wall, and that didn't really happen, and you just say, well, I'm not going to court because that didn't even happen, well,
Makes you look
you're
worse.
out of luck. Not just makes you look worse, but the judge is going to rule on her behalf, and he'll never have the opportunity to hear the truth. No, judge, I did not throw up against the wall. This is what actually happened. She slapped me, and as I was walking out of the house, because I knew she was out of control, she got in front of me, slapped me again, and I was walking out of the house, and our shoulders bumped because she kept slapping me. That's what really happened, Judge. And the judge is never going to hear that story because he never showed up in court. So you better show up in court. Okay. Now, on the flip side, let's say you did throw up against the wall. Okay? And you're not allowed to lie to a judge. That's a criminal act, and it's just wrong anyway. You can't... and if you can't lie on the stand, and if you do get on the stand and tell the judge the truth and say, Judge, yeah, I did throw up against the wall, but you know what? It's the only time it ever happened. I'm sorry about it. It would never happen again. It's just that I was so angry at the time. Guess what? You just incriminated yourself for a criminal case. That's the kind of the scary thing. You incriminated yourself because you said you admitted under oath that you did a criminal act, i.e. a domestic battery, i.e. you grabbed your girlfriend, threw her up against the wall.
Sure.
That's illegal on the criminal level, and so you might find yourself in criminal court if you testify. But on the flip side, if you didn't do that, you better show up to court to tell the judge the truth and say, hey, I didn't do this. This is why I didn't do this. This is what really happened. And then let the judge make a determination about what really happened.
Okay, I got a couple questions then. What about when, let's say, you're divorced or whatever, and your child comes home with bruises or something like that, but you don't know. Let's say you don't know for sure if it's your husband or your ex-husband, maybe it's his parents or whatever. Can you do one, including more than one person on one order of protection? Could I say, you know what, my ex-husband, his parents, his brother, this whole household at blah blah blah, Jones Street. Can you have it on the whole thing?
Sure. You could have more than one respondent. You could have more than one defendant. Obviously, you got to comply with what the statute requires for defendants in order of protection cases. But here's something else that's interesting. Just like orders of protection sometimes coincide with criminal cases, guess what other cases they also coincide with? DCFS cases.
Oh, of course.
Juvenile cases.
Okay.
So your kid comes home with a bunch of bruises all, over his backside. You know that, and you see welts and you think, someone beat him with a belt. I don't know if it was mom. I don't know if it was mom's brother. I don't know if it was mom's, father. I don't know. But somebody did it. It's wrong. You might want to call DCFS, hotline the case, rather than just bringing it into family court for an order of protection, and get DCFS to do an investigation, because DCFS will attempt to get to the bottom of it. And then the case will end up in juvenile court, which is no fun, but it might be the best option for your child, and it might be the best way to come to the bottom of what really happened. Especially in cases where you don't know what happened. DCFS will investigate, and they will send out an investigator, and they've got social workers, and they've got psychologists, and they've got abuse experts who will delve into this and make a determination about whether abuse occurred.
Now, how do you...
Or who did it, for that matter.
So what do you do then if I do have a order of protection or somebody has one against somebody, and it's already set in motion and something happens to where you see this car driving around the street or they're at your doorstep, whatever, you just automatically just call police?
I'd call the police right away.
Right away?
I'd call the police right away. The police will come out, they will document this, and if they find the person, the defendant in the case, they're going to report that to the state's attorney, and that will be then prosecuted as a criminal misdemeanor or a felony in some cases.
Whoa.
Yeah, it's a big deal to violate an order of protection. And what's really, really scary, I think, is that, you've got two people who are boyfriend and girlfriend. And let's say the boyfriend gets an order of protection against the girlfriend because she drew a knife on him.
Right.
And then the boyfriend calls up the girlfriend.
Right.
After the order of protection
I'm sure it happens all the time.
I love you, I miss you, I just want to talk to you. And the girlfriend is like, I can't pick up the phone, I can't pick up the phone, I can't. Finally, she picks up the phone. Boom. That's a violation of an order of protection. She just committed a criminal act.
Whoa.
And so then 2 days later, when their relationship breaks up again, and the boyfriend then calls the police and says, hey, I've got this phone record. She contacted me. Doesn't she? Or not she contacted me, but she talked to me. She can be prosecuted for a criminal act. Now, obviously, the state's attorney has to make a decision about whether they want to do that.
Right, right.
But did she commit a criminal act? Absolutely.
Okay.
Yep.
But I'm pretty sure she can't get out of that, though, saying, hey, I answered the phone and said, hey, I don't want to talk to you, whatever, and plus you have a restraining order against, or order of protection against me.
Why would she answer the phone and say that? She just shouldn't pick up.
Well,
and obviously, I understand that people don't get that sometimes.
Right.
They're like,
self-control, right?
Or they might not understand that if he contacts me first, then I can pick up. But that's what the law is. You can't communicate with them. It protects them, not you. It protects the person who is saying, I've been abused, and when the judge makes a finding that you've been abused, then if you commit a crime, if you pick up that phone when he's calling, and you've been told by the judge, and it's in an order saying that you're not allowed to have any communication with them, you just committed a criminal act.
So does it? There's certain things that are stated in there. If you can still have custody of the child between each other. If I have let's say my ex-girlfriend, whatever, has one against me myself, but doesn't have one with me seeing my kid. We just can't. What happens if we're at school together, or what happens if there's like a meeting?
You're at school together with your kid?
I'm saying, like, let's say you go pick them up or something like that, and somehow bump into each other, or you have a parent-teacher conference or something. I don't know. I'm just trying to put a situation to where you're in the same place at the same time on an accident, because it has to happen.
Yeah,
at the mall, even.
That's tricky. You have to show some kind of intent, some kind of what's called mens rea, some kind of mental state for the criminal act of violating an order of protection. If you accidentally bump into your girlfriend who has an order of protection against you, you're walking on the public sidewalk and there's a million people. You're in at the Taste of Chicago,
right?
And there's 2 million people down there, and you bump into her. Did you just commit a criminal act? No. because there's no intent behind that. You see what I'm saying? But if, you bump into her and then you start talking to her, or you don't immediately step away,
Or make a comment.
or you make a
Right.
comment, you just committed a criminal act.
Huh.
You can't knowingly, recklessly, intentionally violate an order of protection. Accidentally, that's a little different.
Now, what if you decide you want to move to another county? Let's just say from Winnebago to Boone County. Can you have that transferred then? Because you said that some of these do last up to 2 years, correct?
Well, if you move to another county, the order of protection remains in effect. Counties don't. When you move to another county, it's not as if the law does not apply.
Okay.
Where you're living.
Okay.
It's called venue, not jurisdiction.
Okay.
So it's a different venue.
Oh, all right.
If you want to file a petition to modify venue and have the order of protection modified or reinstated,
Right.
let's say you move from Winnebago County to Cook County, okay? And the 2-year period is up, and you want to petition the court to renew the order of protection. You'd file a petition to modify venue because the child and you you live in Cook County, and you want a Cook County judge to address it. And then the second petition would be to renew the order of protection. And people can do that. But it's not as if the law doesn't apply. If you're living in Cook County and a Rockford judge entered an order granting you an order of protection, that Cook County judge has to abide by that. But if the order of protection needs to be modified and you now live in Cook County, or if, say, it needs to be renewed, then you might want to petition the court for a change in venue.
Okay, so what about? I'm guessing there's some situations where somebody might have a longer. I keep saying restraining order, but order of protection. If somebody has a longer one, if I have one against you or I have one against somebody or whatever, what's the process of me getting them removed? Can I just say, you know what? I was in the heat of a moment and I said things and I instigated something, whatever, and I don't think this is necessary for me to have this. Can you go in and say, take it down? Is that something they review first, or they take it down automatically, or how is that?
I've represented clients in those situations.
Okay.
What you have to show is some kind of change in circumstances. You have to show that if you were a violent person, you now no longer are a violent person. How do you do that? Well, did you go to counseling? Did you do anger management classes? Did you do parenting classes? Have you been seeing a psychotherapist? Have you proactively addressed your issues and then have the professional, the shrink, the psychologist, the social worker come and testify on your behalf in court? But you've got to show those change in circumstances. I'll tell you, if you come to court and say, Judge, I'm a different person. I was violent a year and a half ago. Now I'm not. And you have not done any of those things, and you don't have the evidence and the testimony of a professional, judge isn't going to grant your petition to modify the order of protection. And I think where this comes in key is not so much with relationships. Hey, I want to see my ex-girlfriend again or talk to her, but I want to see my kid. And you've got to show the judge that you're being proactive in changing your life and get a professional to testify on your behalf. And a lot of times, letters from professionals are hearsay and they're not admissible in court. But, if the parties agree to waive that, they can get letters, sent from the psychologist saying, hey, this guy's been in therapy for the past year every week. These are all the changes I've seen in his life. Obviously he had an anger management issue now, but now, number one, he's medicated. Number two, these are all these positive things that he's doing, and this is how he's grown. So.
Now, what happens if you know somebody that is getting domestically abused or something like that, and they're just afraid? Because I actually know people personally that are afraid to get that because they feel like he's going to come kill me. Almost like if he gets subpoenaed or not subpoenaed, but if he gets, well, that's right. If he gets served or whatever, I say, okay, I'm finally done with my ex-boyfriend, whatever. I'm going to go file this because I'm getting tired of getting my shit knocked out of me. And how does that work then? Because I mean, sometimes people are afraid to go do that.
Don't be afraid. Don't be afraid. And obviously, I'm speaking as someone who is a professional helping people in these situations.
Of course.
And I don't know the personal experiences they're
Right.
going through. But what else are you going to do? If he's beating the crap out of you all the time, then you need to get an order of protection, because then the police are going to get involved. He will be arrested. The state's attorney will get involved. That's the only way you're going to get protected. And when you initially go to the judge, he doesn't have to be there. So you walk in with the pictures of your bruises, or maybe you can show the judge your bruises. You roll up your sleeve, and you've got bruises all on your forearm where he grabbed you.
Right.
The judge is going to grant you an order of protection. And the order of protection, it hides the residence too. The judge can order that your residence not be disclosed. So let's say you
moved.
Yeah, let's say
Okay.
you flee the house and you moved in with someone, then the judge can order that your residence not be disclosed, so that you're further protected.
Okay, so another thing I was reading, I have a question about, is having to do with disabilities. If you're somebody that has a personal caretaker or whatever, people that come help you out, visiting nurse or whatever, and that person that's helping you out is hurting you or whatever, can you, like an elderly person, well, it doesn't have to be elderly, it could just be somebody with disabilities, is that also
Just like children,
Same
people
thing.
who are elderly and disabled, and who are incapable of filing a petition on their behalf. So maybe they're stuck in their home,
right?
or maybe they're mentally incompetent.
Oh, okay, yeah, good.
Maybe
good
they're
point.
23 years old, but have a very, very low IQ and can't protect themselves. Or maybe they're in a wheelchair and they can't get to the court. A neighbor can file a petition on their behalf. The neighbor comes by and sees that this elderly person is being neglected or is being abused by another family member. They can file a petition on their behalf, just like you can do for a kid.
So same thing. If I'm a neighbor and I'm watching this guy beat the living daylights out of his girlfriend, fiance, whatever. Same thing. I can file it because I know that maybe she's afraid of doing that. I can do it as a neighbor. I can say, you know what? I'm watching this girl get her stuff kicked out of her or whatever.
Right.
And it'd be you. It'd be your name on that then filing it.
You would have to put your name as the petitioner.
Right.
But that's okay.
Same thing. So
Step
if
up to the plate. You see someone getting abused, step up to the plate, put your name on that petition, and go help them. Or in cases involving children, call DCFS. DCFS will get involved and will assist you with that process if you have the hotline, with children at least.
And ultimately, I'm sure they tell you to also call the police right away if you see something like that happening. But
Sure.
I know there's situations where the women are afraid to report it.
One of the best benefits of calling the police is that the police will document things.
Of course.
So, if there is a history of police reports, the police come to the house, and every time they come to the house, they document things. They talk to the parties.
Okay.
They take pictures. So even if they choose not to arrest or refer a case to the state's attorney to prosecute a crime, they're going to do all this kind of documentation. So the second or third time you call the police, you've got prior police reports, which strengthens your case in family court for an order of protection being issued. If there's issues of credibility, is she telling the truth? Is he telling the truth? That kind of thing.
Now, if I want to go file order of protection tomorrow on somebody or whatever, what are some things I should definitely bring if I have them? Is there
Evidence.
anything at all? A text
Pictures.
message or something?
Pictures, text messages, video, police reports. And you can get police reports by filling out a Freedom of Information Act. It takes 5 to 7 days. But bring that to the plenary hearing. Bring that to the hearing where the guy has to show up or the woman has to show up, the defendant has to show up and testify, and boom, you've got these police reports. Obviously, police reports are hearsay. You've got to petition you've got to summon the officers to come and testify. But you can say, Judge, I've got these police reports. Can you please extend the ex parte order of protection? And then I'll have the police summoned to court, subpoenaed to court specifically, and come and testify.
Okay, so how about do you have to, if I'm filing one against somebody the first time when they go to the whole court thing, do you have to be together with them? Do you have to see them, or do
The first time?
Yeah.
No.
Okay, you don't have to be in there.
Hell, heck no. No, that's the whole purpose of
Right.
ex parte order of protections is to keep the abuser
Away.
away and not knowing what's happening because of the severity of the situation. You do not want them in court. You do not want them to have the initial opportunity to be able to testify because they might beat you up or kill you before you even get to court. Oh, by the way, I'm going to court to get an order of protection against you. Oh, no, you're not. You're going to stay in this house, and I'm going to beat you up. No. You go to the court alone with your evidence and tell Judge Bruce or Judge Gully or Judge Norquist or Judge Meyer what's going on, and that's when they grant those ex parte orders of protection if they find that your testimony is credible.
Now, one thing I was reading is there's order of protection and there's an emergency order of protection. What's the big difference there, really? Is there
Emergency order of protection is another term for ex parte order of protection.
Oh, all right.
It means that the court has made a finding that there's some kind of emergency. You're going to continue to be abused. Your boyfriend's going to continue to come home and beat you up, drunk. Mm-hmm. And you've got to have the order of protection without him being able to come and testify because he might beat you up, or if there's a probability that he's going to beat you up again. And then he'll have an opportunity to be in court 2 weeks later to testify if he wants to. But that's the emergency nature of those kinds of cases. Those are the ex parte order of protections.
I guess, where does the whole order of protection thing come in at? Because this is probably one of the first times I heard it as order of protection. Does a restraining order even exist, or is that a real thing, or is that just another word that people use?
Not really.
Okay,
It's more of the common term.
Okay.
The statute provides for orders of protection. We do have no contact restraining orders, say, maybe in divorce cases and family cases. Mm-hmm. I mean, one of the things that if I'm defending a guy who is accused of being abusive, I would much prefer to have a no contact order entered in the D case and do away with the order of protection. Why? Because there's no criminal consequences if he violates it. There's consequences. You can't violate a court order. Mm-hmm. But if it's entered as the defendant shall not contact the plaintiff.
Okay.
But that's to hold him in contempt, as opposed to you just committed a criminal act when you violated the order of protection. So I think that's where people get confused sometimes. But basically, restraining orders are orders of protection.
Is there anything that order of protection does not cover? Like, is there certain things that it does not cover?
Your neighbor beats you up.
Okay.
Orders of protection don't cover that.
So
You have to get a no stalking order.
Okay.
But orders of protection don't cover that. Why? Because you're not household members, nor were you ever household members.
Okay. So yeah, I was gonna say, how's that work when you're neighbors and you live? It could be the no stalking thing, and they pretty much look right through the window or whatever it is. How do you get that? Or even if it's abuse or whatever, how do you get that to be passed? Because they live within 30 feet from your house in some area, maybe less than that.
You get a no stalking order.
Okay.
You get a no stalking order. If you got someone who's looking in your windows, sending you inappropriate texts on a repeated basis, you petition the court for no stalking order.
Okay.
Because what they're doing is they're stalking you. And the other remedy is it's a criminal act. If they're, peeking in your windows, think about all the criminal things they're doing. They're trespassing. If they hit you, that's a battery.
Okay.
If they hit you on the sidewalk, that's aggravated battery. That can be charged as a felony because it's a public place.
Right.
So there's other remedies outside of an order of protection. Obviously, with criminal cases, those are prosecuted by the state's attorney, so they make the decision about whether or not they're going to prosecute the case. But, neighbor does that kind of stuff. You call the police, and the police will come, and they'll ask questions, and they'll probably arrest them.
Okay. All right, thank you, Brad. I learned a lot about the order of protection, also commonly known as restraining order. Hopefully, if there's any questions, can somebody email you or find you?
Absolutely. Give us a call at 815-997-5200, and email at the office is brad@tenglerlaw.com. We deal with orders of protection all the time, whether or not we are filing on behalf of someone or we defend people too in those situations.
And they can also come talk to you, right, for a consultation at first if they want to see if it's worthy of a...
For most family cases, we give a free initial consultation, no obligation. They can come in and talk to us at the office.
That's incredible. And also, don't you have a Facebook as well?
Yep, got Facebook. We're on Twitter, all that kind of stuff.
You have it all. All right, real cool. You just heard a phenomenal episode of Divorce Talk Radio. Listen to Divorce Talk Radio live on RockfordCollegeRadio.com, Tuesday evenings at 8 p.m. To hear more of Divorce Talk Radio shows, please visit RockfordCollegeRadio.com. To learn more information about attorney Brad Tengler, please visit TenglerLaw.com.